The Toowoomba Regional Council has lost a court case in the Supreme Court of Queensland with a group of Hampton farmers. Hampton Irrigators was actually set up in 2001 as a private irrigation scheme. It established a bore at Clinton under agreement with the then Crow's Nest Shire Council. Dan Creevey is the lawyer representing the irrigators. Good morning.
Good morning, Belinda.
So remind me the details of this particular case.
Belinda, it's a dispute involving the Hampton Irrigators and the Toowoomba Regional Council, basically involving a water supply agreement, that originated way back in the year 2000 when the investigations for the bore were commencing with the Hampton Irrigators.
And what was the outcome in court yesterday?
Well, the outcome was that the Supreme Court of Queensland made some declarations, in effect, that the purported termination of the agreement by the Toowoomba Regional Council was invalid, and that the water supply agreement remains on foot or is binding between the parties, and further, that the bore water is suitable for human consumption.
Does that set a precedent in terms of Toowoomba Regional Council's operations in the future?
Look, I couldn't say to go how far it will go. It's restricted to the issue between the parties in this particular case.
Does this mean that the water will be switched back on and supplied to Hampton Irrigators as per that original agreement?
Yes, absolutely, yes.
And what's been the reaction so far from the irrigators?
Very, very happy. They've been negotiating and attempting to sort this matter out with the Toowoomba Regional Council, and it was an unfortunate situation. They had no alternative but to take the matter to the Supreme Court. They were vindicated in that decision too, Belinda, because the Supreme Court awarded costs against the Toowoomba Regional Council on the indemnity basis, and made a very significant comment in that regard, that in this case the Toowoomba Regional Council has allowed these proceedings to continue when it should have known that it had no chance of success.
And what costs are you anticipating? Well, what sort of figure are we talking about?
Look, indemnity costs are the costs on the highest possible scale in the Supreme Court. So basically all of my legal firm's costs, we engaged the Queen's Counsel, Mr David Cooper, to argue the case for us. So all of those costs will be covered in the indemnity costs.
Has this happened before, to your knowledge? A local council has to pay farmers, for example?
Well, look, we're not aware of it. We are aware that the Toowoomba Regional Council has been ordered to pay costs in other matters, but I'm not aware in these particular circumstances, Belinda. And
has there been any response from Toowoomba Regional Council? Do they have the right to appeal? Are you expecting that?
They can appeal. That's a right of appeal. So the decision only came down yesterday, so we haven't heard a word from the council as yet, or any of the councillors.
So what sort of period of time would they have before they can appeal, which would extend this out, I assume?
Yeah, if they do choose to appeal, they've got 28 days.
Well, thank you very much for updating us this morning.
Thanks, Belinda. My pleasure.